Hi friends, today I would like to discuss with you one of the pivotal and important judgment of the Honorable High Court of Delhi. It's related with Negotiable Instrument Act. As we know that cases under section 138 of the Negotiable Instrument Act can be filed before the Metropolitan Magistrate Court or Judicial Magistrate First Class. In this case, the question arose before the Honorable High Court of Delhi that once the accused has issued the check and he has contended that the said check was issued by him as a security check, and thereafter the said check has got dishonored, and the complainant has filed the case under section 138 of the Negotiable Instrument Act after following the due process of law like issuance of the notice, etc. And the court has issued the notice. The petitioner, that is the accused, went in the Honorable High Court to get it quashed and set aside. He filed the writ petitions bearing number 1366 of 2023, and the name of the judgment is Payal Malhotra versus Sulekh Chand. In this case, the Payal Malhotra was the petitioner and she was the original accused. The contention raised by the petitioner in the said case was that if the accused issued the check to the complainant as a security check that is given in the advance, and that has got bounced, then whether section 138 is attracted or not, that was the question. And the contention of the petitioner was that the if the check is issued for as a security check or given in as an advance, then it does not attract the provision of 138 Act. The Honorable High Court of Delhi, in the said judgment, has positively decided the case and stated that if the accused issues the check as a security check in favor of the complainant and that has got bounced, in that case it attracts the provision of 138 of the Negotiable Instrument Act. Apart from that, the Honorable High Court of Delhi has gone ahead and said that not only the security check but also if the stop payment is made, like accused issues the check to the complainant and thereafter he stops the payment or he closed the account, in all three such a cases, like if the account is closed, stop payment is made, or the security check is given, in all such a cases the court said that it attracts the provision of 138 of the Negotiable Instrument Act and the case is tenable. Therefore, the court said that quashing proceeding, the court, Honorable High Court, is not under obligation to appreciate the evidences, etc. Actually, appreciation of the evidences need to be done by the trial court only. Therefore, it is not proper to jump to the Honorable High Court for quashing. And if the contention of the accused is right, for example, in saying that the case is not maintainable and he has issued the check, he or she has issued the check as a security or whatever, then the accused has got the right to take the same plea, same contention before the learned magistrate and not before the High Court. Therefore, the petitioner or accused is at the liberty to take the same contention, and whether he should be framed, whether the case should be contested against him or not, that burden is on him. He need to prove the same in the court of trial only, that is GMFC court or Metropolitan Magistrate Court. Therefore, the work of appreciation of evidences is not shifted on the High Court. High Court is not under duty to appreciate the evidences. The High Court cannot steps into the shoe of the trial court. Therefore, the Honorable High Court of Delhi has dismissed the writ petition number 1366 of 2023 without issuing any notice to the respondent and laid down a law that even if the check is issued as a security check, or even if the check is issued thereafter, stop payment is stopped by making an application to the bank, or after issuance of the check, the accused closed the account. In all such a three cases, the case under 138 of the Negotiable Instrument Act is maintainable. While deciding the said, the Honorable High Court has relied on one important judgment of the Supreme Court, that is Dashrath Bhai Trimbak Bhai Patel versus Hitesh Mahendra Bhai, which was decided in the year of 2022 by the Honorable Supreme Court in Appeal number 1497 of 2023. In this judgment, that is Dashrath Bhai Trimbak Bhai Patel versus Hitesh Mahendra Bhai, the Honorable Supreme Court said that even if the security check is given, the security check is to be treated like a responsibility in case if the person, for example, if a person has taken a loan and he's under obligation to pay the regular installment, monthly installment. However, the bank or financial institution takes the check in advance like a security check. In case if the customer, that is the account holder, uh, fail to pay the regular monthly EMI, in that case, the bank has got, financial institution has got the right to deposit the security check. In such a cases, it can be very well said that the said check was issued in respect of discharge of the legally enforceable debt. Therefore, the provision of Section 138 of the Negotiable Instrument Act is applicable. At the same time, the Honorable Supreme Court said in this judgment that if it is proved or prima facie it is established by the customer or borrower that he has paid the all EMI and he has discharged his all enforceable debt, in such a cases, if the bank or financial institution deposits the security check, in that case there is no legally enforceable debt upon the borrower because he has already discharged his liability. So it is conditional. In case it means if the accused has discharged his all liabilities and he has made the payment, he has got the evidences that he has made the entire payment, in such a cases, security check, if it deposited by the complainant, it got bounced. In such a cases, case under Section 138 of Negotiable Instrument Act does not survive, or it does not attract the provision of Section 138. Whereas if it is established that there were failure to pay the regular monthly installment, in such cases, the security check which was given, it was like a pawn and it was like a responsibility. Therefore, the provision of Section 138 of the Negotiable Instrument Act is applicable. Now, the Honorable High Court of Delhi in Payal Malhotra versus Surek Chand case that was filed for quashing purpose said that the accused can move the trial court, Metropolitan Magistrate Court or Judicial Magistrate Court and can lead his evidences, and burden is on him to prove whether the case should be framed by the court or not. Directly he cannot come to the High Court for quashing, and High Court cannot step into the shoe of the Metropolitan Magistrate Court or JMFC. Therefore, there are so many opportunities available to the accused to prove that the said check was not issued by him for discharge of his duty, discharge of his legally enforceable duty, but for other purposes, etc. He can also recall the witnesses under the provision of CRPC, and he need to prove that why he should not be framed in the case. However, directly jumping to the Honorable High Court under quashing proceeding by way of writ or under Section 482 of the CRPC is not justifiable, because the High Court cannot steps into the shoe of the Metropolitan Magistrate Court, and the High Court is under its writ petition or writ jurisdiction or quashing proceeding cannot appreciate the evidences. That is the work of the trial court only. And the applicant has to come step by steps. He cannot directly come. Now, conclusion of the judgment in Payal Malhotra versus Sulek Chand is that even if the check has been issued as a security, or even if he stops the payment after issuance of the check, or if the accused close the account after issuance of the check, in all such a three cases, section 138 of the Negotiable Instrument Act it gets attracted, and case is tenable under section 138 of the Negotiable Instrument Act. And the another judgment of the Supreme Court, that is Dashrath Bhai Trimbak Bhai Patel, says it is conditional if it is proved by the accused that he has, if it prima facie he establishes that he has paid the entire obligations, then security check remains to be as a paper only, and it is not issued in discharge of his legally enforceable debt. However, if there is a failure to pay the monthly installments, then still there is a liability on the part of the borrower. In such a cases, if banks or financial institutes deposits the said check, security check, in such a cases, provision of 138 of the Negotiable Instrument Act is applicable. Hope that you have understood. Hope that I have explained in right way. Hope that you like my lectures. Thanks for your cooperation in hearing me.